Hi, my name is Michelle Whitehead. I'm an Australian lawyer and I provide business serenity to entrepreneurs, professional creatives and creative professionals through wise management and legal support. Welcome to my masterclass on contracts that care. First, a little bit about me. I am a homeschooling mum with 3 kids, aged 10, 8 and 4, and we have wonderful adventures together. And that is probably the best thing for me about working from home and why I have always insisted on working from home. I'm also a lawyer. I'm a small business lawyer. I've been a lawyer for over 8 years now, specialising in the needs of small business and in particular contract drafting and writing. I also do legal research for academics and for barristers, and I do generalised research for people who are writing or presenting at conferences. I research the background theory for their work, current trends, that sort of stuff. And I'm also an accredited mediator. I do family dispute resolution, but my passion is in the resolution of civil disputes. So, for example, disputes between small businesses, providing a better way to resolve disputes rather than going to court, finding ways to reach win-win solutions, to work things out in the way that is most effective and most tailored to your own personal situations and circumstances, helping people to reach their own resolution for a dispute rather than having one handed down to them by a court. And I'm also an entrepreneur, and that is the thing that makes my heart sing. I absolutely love reinventing the way we do business, reinventing the way the law works for small businesses, really working out how to create a world based on connection and caring rather than competition. So today I'm going to give you an overview of contracts. We're going to start with looking at when is a contract necessary? What does it actually do for you? We're going to look at the contrast between the traditional perspective of contracts and the contracts that we're creating today for the new business paradigm. Then we're going to look at what are the basic elements of a contract? What does every contract need in order to be a valid contract? And we're going to look at some of the terminology that is used in contract formation and explain where that's all coming from. And finally, we're going to look at why, and I'm going to get ranty about the importance of having contracts for your business, because contracts are really a caring thing rather than a thing based in fear and avoidance as the traditional legal system has presented them. So when are contracts important? And this picture illustrates to me both the traditional perspective of contracts as something that is legally enforceable. It's all about enforcement. It's all about someone having the power to enforce a contract. But it's not really like that. The people who enter into an agreement can often, both of them, feel like they are naked and vulnerable and exposed, that they are taking a risk, and that the other person, the other party to the agreement, has all the power, has them at a disadvantage. And so therefore the contract tends to become sort of a David and Goliath type instrument, but it's not like that at all. Contracts are actually really, really useful for addressing that kind of power imbalance, for levelling out the playing field, for making sure that everybody's rights are set out clearly and everybody's obligations or duties or what they have to do are also set out clearly. They're a brilliant way for ending doubt and confusion and uncertainty. And those things, doubt, confusion and uncertainty, they are what are the biggest cause of business relationships going wrong, because people just didn't know what to expect, what they were getting into, what they were required to do. Expectations, mismanaged expectations, all of those sorts of things, they are what are at the root cause of any kind of problem that arises in most cases. So contracts are actually protection. They're protection for both people. They're the protection of knowing what's happening, what's expected of you, and what you can expect. And they're the protection of knowing at the end result, if things do go terribly, terribly wrong, then you have the protection of the courts. They are the protection for the person who's making the offer. They know they have the protection in the contract of knowing that how and when they will get and what they will get paid is clearly set out. They are the protection for the person who is accepting the offer of knowing what services, what products, what they can do if they have a problem. It's all clearly set out. So contracts are important in any kind of relationship where there are rights and obligations that need to be protected, that need to be set out clearly, where expectations need to be managed. So what are the basic elements of a contract? Every contract, no matter whether it's for coaching, for buying a product, buying a service, every entering into a joint venture, a collaboration, a loan, every single contract has to have these elements. These are the basic elements of contract in order to be a valid contract. And I'm going to use the word legally enforceable quite a bit while I'm talking about these, simply because the main traditional reason why you would want a valid contract is so that it is legally enforceable. But legal enforceability is not, in my mind, the be-all and end-all of contracts. Certainly, it's a very important element in the event that something does go terribly wrong. But to me, the whole point in having a contract and having a good contract is to avoid ever needing it to be enforced. A good contract sets out the obligations and rights so clearly and gives everybody so much clarity and manages the relationship so well that legal enforceability never becomes an issue, because the relationship does what it's supposed to do and ends happily. And there is no problem there, because every potential problem and every way of dealing with unforeseen problems is already covered in the contract. So let's look quickly at those basic elements. The first part of the contract, it has to be about a bargain. There has to be some give and take involved. And it has to be a particular type of give and take. So there has to be an offer, which means one person in the contract is offering something. They're offering goods, they're offering a service, they're offering to do something, they're offering to give something, there's some kind of offer involved, and then there's some kind of acceptance. So there's somebody saying, yes, I want that. And if there's just the offer and acceptance, then it can be a voluntary agreement, and a voluntary agreement is not a contract. To make it a contract, there has to be consideration, and that means that there is some kind of exchange of value. So it's not just saying, I'll do this for you, yes, that would be great. There's, I'll do this for you if you give me this. Yes, that would be great. Here it is. So that can be, consideration can be money. So it can be, I will write you this contract if you pay me this amount of money. Yes, here, agreed. I do the contract, you give me the money, contract done. Or it can be services. So swapping services for services can be part of a contract. It can be any type of exchange, and it doesn't matter how big the exchange is. There can be what's called nominal consideration. So it could be as much as $1 in order to make it a valid contract, so long as there is something that has value to the person making the offer that is given to them in exchange for the product or service that they offer. So it can be something that's very personal to the parties. It doesn't have to be something that is externally objectively valuable. It only has to be personally valuable to the people making the offer. The next thing that a contract has to have is parties. So there have to be people to the contract. And the reason we call them parties instead of people is that those parties can be any kind of legal entity. That includes a company, a corporation, a partnership, a trust. A party to a contract can be any kind of legal entity, so any kind of legal being that has a legal existence. And in order to be a valid contract, the identity of those parties must be really clear. You must be able to say with certainty who the parties to that contract are. So that's why if you see a contract, it will have people's full names, it will have their addresses, it will have their ABNs or their ACNs. That identity is a very important part of establishing that there is a valid contract, and all the people whose rights or obligations are affected under the contract must be a party to that contract. A contract cannot bind a third person who's not a party to it. The next thing, the parties have to be competent, and in this we just mean that they're adults over the age of 18. A minor is not competent to enter into a contract. It gets a bit more complicated in areas of intellectual disability, whether someone is competent or not competent to enter a contract. The basic standard is that they understand what they're getting into. The next issue is capacity to enter into the contract. So this means that you are able to fulfill the obligations that you're entering into. Now, for example, if I entered into a contract to pay you $1 million for providing me with this particular service, and the service was worth $1 million, and then I suddenly said, oh, actually, no, I actually have no way to pay you that $1 million. I don't have $1 million. I don't have any assets that are worth $1 million. I have no way to do this. Then the other party would have an action against me for breach of contract. So that's a different thing. Capacity in order to form a valid contract that would be breach of contract. Capacity in order to form a valid contract means that the thing you are contracting to do is capable of being done. For example, if we entered into a contract where I said, I'll transport you to the moon in 30 seconds if you pay me $1 million, we got into an argument that said, we haven't fulfilled our contract, there's breach of contract, the court would likely to throw that out and say, look, neither of you had the capacity to fulfill that contract. That contract is void for uncertainty because there's void for lack of capacity. And the last element for the parties in forming a valid contract is intention. So both parties must have an intention to create legal relations. Now, if this is an arm's length agreement entered into by two business people, then intention is presumed. That means you are presumed to have intended your contract to be legally binding. This is to distinguish it from, for example, contracts between family members or contracts between agreements between best friends. So, for example, if I say to my son, I'll pay you $5 if you take out the garbage, there would be a presumed the courts would presume there was no intention to create legally binding relations in that situation. So basically, to make it really clear, most contracts will say that we intend this contract to be legally binding. And the last element that is common to all contracts is the obligations. And there has to be a mutuality of obligations. If a contract is well and above one-sided, if all of the advantages and the benefits are on one side and the other side just has to give, then a contract is not going to be a valid contract because there is going to be too big a power balance. There really has to be a mutuality, a give and take in a contract. The second thing is that the activities that you are contracting to do have to be lawful. You cannot enter into a valid contract to do an unlawful activity simply because the courts won't enforce that. It's an invalid contract. So, for example, if a contract to supply drugs is an invalid contract that the courts won't enforce, and that's pretty obvious. And the last thing is that the obligations have to be clear and certain. This is not just for your own benefit, it's also everybody has to know with absolute certainty what they are getting into and what they're getting out of it. So if something's vague, if it's sort of example, I'll do this for you when this is, when something else happens, if something else happens, then the contract is going to be void for uncertainty. It really needs to set out in detail with as much specificity as possible what you are agreeing to. So, and what you're required to do as to fulfill your half of the bargain. So dates, amounts, how things are going to, what you're going to do if things go wrong, backup plans, it all has to be spelt out in as much detail and as specifically as possible. So those are the basic elements of a valid contract. So one of the questions I get asked relatively often that I'd like to clarify here for you is, what is the difference between a contract and terms and conditions? So as we've seen, there are many different types of agreements, and a contract has specific requirements in order to make it into a valid contract. Terms and conditions and a contract are very, very similar. When you have terms and conditions on your website or terms and conditions of a sale, it's like a pseudo contract. The difference is that it's never negotiated individually. Your terms and conditions are yours. So it's like going back to that power structure before. You're the person imposing the terms and conditions, and anyone coming to you has to either take them or leave them. So if your terms and conditions are drafted well and they're binding, it's like you are the monolith setting up the terms and conditions, and the other party is just a generic general party. So it's any of your customers, any of your clients. There's a lot less flexibility built into them, a lot less freedom to negotiate. And they're usually a lot more general. They're not as specific, as customized to the individual relationship. And they're best for simple relationships where you're selling one to many over a long period of time. When you're selling one-to-one, or in a relationship one-to-one, a business relationship, such as a collaboration, or in a course relationship where it's one to a limited group, that's where a contract is more important. I mean, you can get a single contract drafted up which covers your basic requirements and has flexibility built in, where you can adapt and customize certain, like you have certain clauses or aspects in it that can be adapted or customized to the individual, but the overall contract structure remains the same. And you just basically amend it and adapt it as required for each person. And that usually happens in schedules. So the main body of the contract stays the same. And at the back you have schedules which are referred to in the contract. And in those schedules you can add in the individual details for each specific person that you're entering into the relationship with. So for example, if you were doing a course and you offered a negotiable type of payment plan, your course contract would be the same for every person who joins the course. But the payment plan schedule that's referred to in the payment clause of the course contract would be adaptable. You could say for one person, so much per month. You could say to another person, so much per week. You could say, or per fortnight. You could say another person's paying in full. Whatever arrangement you negotiate with each person coming into your class about how they're going to pay you, that can be different in the schedule, with the main contract remaining the same. And so you can reuse the contract throughout the course and have the flexibility and freedom to adapt it yourself. That is not usually available with terms and conditions. Terms and conditions are generally sort of set in stone. And because of their generic nature, there is that less detail of specificity. And the reason that terms and conditions are not a contract and not enforceable, okay, so they are arguably enforceable as a contract, but only to a certain extent. So only up to a certain value. You wouldn't have terms and conditions for a higher value offering because of the risk that when you got to court or you got into an argument about it, that someone would say the identity of the parties wasn't clear or their acceptance of your terms and conditions wasn't clear. It gets into that mix between clarity and certainty. identity and intention and offer acceptance. So there has to be that mutuality, that joining up between them. That's why when you're entering into any kind of relationship that has high value to you and to the other person, particularly high financial value, but also high risk value. So for example, if you're exchanging services or you're both putting a lot of your time and effort into a collaborative venture, that's why it's good to have a contract that makes it really clear what your intentions are, what your mutual obligations and rights and responsibilities are, what you each expect to get out of it, and how you envisage it going forward. So here's where I'm going to get a bit ranty, because contracts are so much more than just an externally exposed expectation on your business. They are the ultimate in self-care. I've had clients come to me and say, why should I bother getting a contract when no one ever reads them anyway? You know, contracts, I've had people say to me, I never read contracts, I just sign them and go. And that is such an impoverished view of what contracts can do for your business. Contracts are where you set your intention for how you want a relationship to develop. Contracts are how, as I think Shalini said the other day in one of her little memes she created, contracts are how you create your ideal client by telling them what you want from them. Contracts are where you really, really serve your clients by showing them exactly what it is that you're giving them, and also by spelling out in detail what you're not giving them. It's where you manage your liability, where you show them that, yes, you can rely on me for this, this, and this, but the service I'm providing you does not do this, this, or this. You know, it's like where you say, I provide, my service is not a substitute for this other service. It's where you set out your dispute resolution desires, so that if something does go wrong, at this early stage of the relationship, when everything's really good and you're happy and friends with each other, you have agreed already on what you're going to do and how you're going to resolve things if everything goes pear-shaped. And it's not even if the relationship breaks down. What if externally imposed things that neither of you have any control over? What do you do in those situations? A contract lets you think about all of that stuff at the start and plan for it in advance. And it helps you plan for the impossible too, because it allows you to put into place the things that you will do in case of the unexpected. So for example, you can have it that if there's a problem, that you will negotiate about it first, that you might go to mediation or some other form of alternative dispute resolution. So it allows you to build in steps between you as good friends working together for if the relationship breaks down, put in steps as to what needs to happen before you hit the courts and start wasting a lot of time and money and stress. And it allows you to set your vision. It really is the ultimate expression of your vision for the relationship. And as I think I said earlier, it's not set in stone. It's not something that is handed down fait accompli. So a contract is something that can be negotiated. You come to a lawyer, you get the contract drawn up, all perfect the way you want it. And then there's the negotiation phase where your clients or your co-workers or your employees or whoever it is you're working with, in a contract that cares, they can come back and say, hey, look, I'm not really happy about this, or I'm worried about that. Can we put it in? And you can make sure that everybody's concerns in the situation are covered, that everyone knows what they're getting into, what they're getting out of it, knows what their requirements are. And it can be really flexible. You can build flexibility into the contract. So contracts are more than a must-have, a should-do. A good contract is a caring container. It holds that sacred space where business relationships can bloom. It basically sets the boundaries and manages the expectations so that you can go and do your own thing, do what you do so brilliantly, knowing that all the details are taken care of, knowing that you don't have to worry about misunderstandings or miscommunications, because everything that's important to you and everything that's important to them has been set out in detail. And there's one other advantage of having a contract that I want to expand on, and that is the way in which contracts can assist with mindset. I have regularly had clients say to me that their course or their collaboration didn't feel real until they had nailed all the details into their contract, until they had really put that effort into thinking about exactly what it was that they were wanting to provide, what they were wanting to receive, and how the relationship would work in specific terms. That whole process of bringing the details out from your imagination and putting them down on paper and arranging them in a nice, comprehensive, clear manner, and then having that box at the end where people can sign to accept your offer, or where you can both sign to formalize your relationship. That goes a long way from taking your business from feeling like a hobby to really feeling like a serious business. It also goes a long way in terms of grounding your castle in the air. And this is my basically my signature theme song. When we are, as entrepreneurs, we are so encouraged, particularly as startups, to just get out there and push, 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 build, 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 and not think about the details so much, just to go with the flow, get it out there, get it done. And when we do this, we build this amazingly gorgeous castle in the air. And then there gets to a point where we're ready to expand, we're ready to level up, we're ready to make it bigger. But it all feels shaky and uncertain to us. It's got that instability, impermanence to it. It doesn't feel grounded. It doesn't feel safe. And getting contracts in place, getting your client relationship contracts in place, getting your course relationship contracts in place, getting your collaborative relationship contracts in place, getting those contracts there, getting your affiliate relationship contracts in place, these relationships that have just been flying on a wing and a prayer, that have just been working through mutual goodwill, but that somehow don't quite feel real, don't quite feel solid, don't quite feel safe. Contracts can be the deciding factor that flips them into feeling solid, real, safe, grounded in the real world. So that brings us to the end of my masterclass on contracts that care. I hope the explanations have been clear and useful to you, and that if you have any questions at all or anything you'd like to discuss or explore further, I'm always happy to chat. Connecting with entrepreneurs is my absolute favourite thing to do. And so please just reach out, and I'd love to connect with you and explore these ideas. And if I can assist you, of course, I'm always willing to do that too. So I hope you have a lovely day, and I look forward to seeing you in all of the groups. Bye.